issue simply imposed the minimum coverage provision as a possible way of dealing with that, and if you don't have the minimum coverage provision, then essentially adverse selection runs rampant. But that's not what happened. Congress included at least half a dozen other provisions to deal with adverse selection caused by bringing in people who were less healthy into the Act. There are, to begin with, the Act authorizes annual enrollment periods, so people can't just show up at the hospital. If they don't show up and sign up at the right time, they at least have to wait to the time next year. That's authorized by the Act. With respect to the subsidies, there are three different things that make this important. First of all, the subsidies are very generous. For people below 200% of the federal poverty line, the subsidy will cover 80% on average of the premium, which makes it attractive to them to join. The structure of the subsidies, because their income, they create a floor based on the income of the person getting the insurance, and then the government covers everything over that. And this is important in adverse selection because if you do have a change in the mix of people and average premiums start to rise, the government picks up the increase in the premium. The amount that the person who is getting insured contributes remains constant at a percentage of his or her income. And the third thing is
there's nothing about federal support that is unsustainable, right? That is infinite.
Well, I mean, that's a fair point, Justice Scalia, although one of the things that happens if you take the mandate out, while it is true that the subsidies that the government provides to any individual will increase and they will be less efficient, I'm not disputing that point. Actually, the overall amount of the subsidies that the government will provide will decline, as the government notes itself in its brief, because there will be fewer people getting them. Some people will opt out of the system even though they're getting subsidies. But I'd just like to go back for one more second to the point about how the subsidies are part of what Congress was using, because the other thing is that for people at below 250% of the federal poverty line, Congress also picks up and subsidizes the out-of-pocket costs, raising the actuarial value. And so you have all of that, and then you have Congress also, unlike the states, establishing, or I should be precisely accurate, unlike almost all the states, establishing an age differential of up to 3-to-1. So an insurance company, for example, that is selling a 25-year-old a policy for $4,000 can charge a 60-year-old $12,000 for exactly the same coverage. The states, typically in the 90s, when they were instituting these programs, they either had pure community rating, where everybody is charged the same premium, everybody, regardless of their age, is charged the same premium. Some states had a variance of 1.5-to-1. Massachusetts, for example, which did have good subsidies, but their age band was 2-to-1. So when Congress is enacting this act, it's not simply looking at the states and thinking, well, that didn't go very well. Why don't we put in a minimum coverage provision? That'll solve the problem. Congress did a lot of different things to try to combat the adverse selection. Now, if I could turn to the finding, because I think this is the crux of the government's position, and then the plaintiffs pick up on that and then move from that to the rest of the Act. And it seems to me, quite honestly, it's an important part because that is textual. You know, in this whole sort of quest for what we're trying to figure out, the finding seems to stand out as something that the court could rely on and say, here's something Congress has actually told us. But I think the real problem with the finding is that the context in which Congress made it. It's quite clear that if the court wants to look, the findings on page 43A, of the Solicitor General's severability brief in the appendix. But the finding is made specifically in the context of interstate commerce. That is why the findings are in the Act at all. Congress wanted to indicate to the court knowing that the minimum coverage provision was going to be challenged, wanted to indicate to the Court the basis on which it believed it had the power under the Commerce Clause to enact this law. Why does that make a difference with respect to finding I, which is the one that the government is relying on, and in particular the last sentence, which says this requirement is essential to creating effective health insurance markets in which guaranteed issue and pre-existing illnesses can be covered? And the reason is because the word essential in the Commerce Clause context doesn't have the colloquial meaning. In the Commerce Clause context, essential effectively means useful. So that when one says in Lopez, when the Court says Section 922Q is not an essential part of a larger regulatory scheme of economic activity, it goes on to say in which the regulatory scheme would be undercut if we didn't have this provision. Well, if that's all Congress means, I agree with that. The system will be undercut somewhat if you don't have the minimum coverage provision. It's like the word necessary in the necessary proper clause. It doesn't mean, as the Court has said on numerous occasions, absolutely necessary. It means conducive to, useful, advancing the objectives, advancing the aims. And it's easy to see, I think, that that's what Congress
Any dictionary that gives that
I'm sorry, Justice Scalia.
definition of essential? It's very imaginative. Just give me one dictionary.
Well, but I think my point, Justice Scalia, is that they're not using it in the true dictionary sense.
How do we know that? When people speak, I assume they're speaking English.
Well, I think that there are several reasons that I would suggest that we would know that from. The first is, as I say, that the findings themselves, Congress says at the very beginning, the head of it is Congress makes the following findings, and they're talking about the interstate commerce. B is headed effects on the national economy and interstate commerce. So we know the context that Congress is talking about. It is more or less quoting from the Court's Commerce Clause statements. But if one looks at the very preceding finding, which is finding H, which is on 42 over onto 43, Congress at that point also uses the word essential in the second sentence. It says this requirement, and again we're talking about the minimum coverage provision, is an essential part of this larger regulation of economic activity, which is, by the way, an exact quote from Lopez, in which the absence of requirement would undercut federal relation, also exact quote from Lopez. But what it's referring to is an essential part of ERISA, the National Health Service Act, and the Affordable Care Act. It can't possibly be, even the plaintiffs haven't argued, that those acts would all fall in their entirety if you took out the minimum coverage provision. And as a second example of the same usage by Congress, the statute that was before the Court in Raich, Section 801 of Title 21, the Court said that the regulation of intrastate drug activity, drug traffic, was essential to the regulation of interstate drug activity. Again, it is simply not conceivable that Congress was saying one is so indispensable to the other, the way the United States uses the term here, so indispensable that if we can't regulate the intrastate traffic, we don't want to regulate the interstate traffic either. The whole law criminalizing drug traffic would fall. So I think once you look at the finding for what I believe it says, which is we believe this is a useful part of our regulatory scheme, which the Congress would think in its own approach would be sufficient.
Counsel, the problem I have is that you're ignoring the congressional findings and all of the evidence Congress had before it that community ratings and guarantee issuance would be a death spiral. I think that was the word that was used, without minimum coverage. Those are all of the materials that are part of the legislative record here So even if it might not be because of the structure of the Act, that's post hoc evidence. Why should we be looking at that as opposed to what Congress had before it and use essential in its plain meaning? You can't have minimum coverage without what the SG is arguing, community ratings and guaranteed issue. You can't have those two without minimum coverage.
Well, I think that's a fair question, but the idea that all the information before Congress only led to the idea that you would have death spirals seems to me to be contradicted a little bit, at least, by the CBO report in November of 2009, which is about 4 months before the Act passed, where the CBO talks about adverse selection. Now I want to be clear. This is at a time when the minimum coverage provision was in the statute, so I'm not suggesting that this is a discussion without that in it. But nonetheless, the CBO goes through and talks about adverse selection and points out the different provisions in the Act, the ones I've mentioned, plus one other, actually, where in the first 3 years of the operation of the exchanges, those insurance companies that get sort of a worse selection of consumers will be given essentially credits from insurance companies that get better selection.
Do you want us to write an opinion saying we have concluded that there is an insignificant risk of a substantial adverse effect on the insurance company? That's our economic conclusion, and therefore not severable. That's what you want me to say?
Doesn't sound right the way you say it, Justice Kennedy.
But you don't want them to say either that there's a death spiral. You don't want us to make either of those two findings, I'm assuming.
That's correct. No, I agree that there's a risk. The significance of it, people can debate. But what I think is lost in that question, and I didn't mean to be whimsical about it, I think what is lost in a little bit is what's on the other side, which is the fact that if you follow the government's suggestion, if the Court follows the government's suggestion, what is going to be lost is something we know is a central part of the Act. I mean, indeed, if one sort of looks at the legislative history more broadly, I think much of it is directed toward the idea that guaranteed issue and community rating were the crown jewel of the Act. The minimum coverage provision wasn't something that everybody was bragging about. It was something that was meant to be part of this package. I agree with that. But the point of it was to have guaranteed issue and minimum coverage. Guaranteed issue and community rating. And that's under the government's proposal. Those would disappear. We would go back to the old system. And under what I think is the proper severability analysis, the real question the Court is asking, should be asking, is would Congress rather go back to the old system than to take perhaps the risk that you're talking about, Justice Kennedy?
You're referring to the government's second position. Their first, of course, is that we shouldn't address this issue at all.
That's correct.
I asked Mr. Kneedler about what procedure or process would be anticipated for people who are affected by the change in the law and the change in the economic consequences. Do you have a view on how that could be played out? It does seem to me that if we accept your position, there has to be a broad range of consequences, whether it's additional legislation, additional litigation. Any thoughts on how that's going to play out?
Well, if the Court adopts the position that I'm advocating, Mr. Chief Justice, I think what would happen is that the Court would say that the minimum coverage provision, by hypothesis, of course, is unconstitutional, and the fact of that being unconstitutional does not mean the invalidation of any other provision. So under the position I'm advocating, there would no longer be challenges to the remaining part of the Act.
But if the challenge is what we're questioning today, whether if you're an insurance company and you don't believe that you can give the coverage in the way Congress mandated it without the individual mandate, what type of action do you bring in court?
If the court follows the course that I'm advocating, you do not bring an action in court. You go to Congress and you seek a change from Congress to say the minimum coverage provision has been struck down by the court. Here's the information that we have to show you what the risks are going to be. Here are the adjustments you need to make. One of the questions earlier pointed out that states have adjusted their systems as they've gone along, as they've seen things work or not work. You know, I was talking earlier about the different ratio for ages in the insurance. The states have tended to change that because they found that having too narrow a band worked against the effectiveness of their programs. But they did, except for Massachusetts, they didn't enact mandates. So to answer your question directly, Mr. Chief Justice, the position I'm advocating would simply have those pleas go to Congress, not in court. Now, if one, just to discuss the issue more generally, if that's helpful, I think that if there were situations where the court deferred, let's say, for discretionary reasons, the court said we're not going to take up the question of severability and therefore not resolve it in other situations. It certainly seems to me that in enforcement actions, for example, if the time comes in 2014 and somebody applies to an insurance company for a policy and the insurance company says, well, we're not going to issue a policy. We don't think your risks are ones that we're willing to cover. It seems to me that they could sue the insurance company and the insurance company could raise as a defense that this provision, the guaranteed issue provision of the statute, is not enforceable because it was inseverable from the decision, from the provision that the court held unconstitutional in 2012.
Let's consider how your approach severing as little as possible thereby increases the deference that we're showing to Congress. It seems to me it puts Congress in this position. This act is still in full effect. There is going to be this deficit that used to be made up by the mandatory coverage provision. All of that money has to come from somewhere. You can't repeal the rest of the act because you're not going to get 60 votes in the Senate to repeal the rest. It's not a matter of enacting a new act. You've got to get 60 votes to repeal it. So the rest of the act is going to be the law. So you're just put to the choice of, I guess, bankrupting insurance companies and the whole system comes tumbling down, or else enacting a federal subsidy program to the insurance companies, which is what the insurance companies would like, I'm sure. You really think that is somehow showing deference to Congress and respecting the democratic process? It seems to me it's a gross distortion of it.
Well, Your Honor, the difficulty is that it seems to me the other possibility is for the court to make choices particularly based on what it expects the difficulties of Congress altering the legislation after a court ruling would be. I'm not aware of any severability decision that has ever looked at anything.
That wouldn't be my approach. My approach would say if you take the heart out of the statute's gone. That enables Congress to do what it wants in the usual fashion, and it doesn't inject us into the process of saying this is good, this is bad, this is good, this is bad. Seems to me it reduces our options the most and increases Congress's the most.
I guess to some extent I have to quarrel with the premise, Justice Scalia, because at least the position that I'm advocating today, under which the court would only take out the minimum coverage provision, I don't think would fit the description that you have given of taking out the heart of the statute. Now, I do think once you take out guaranteed issue and community rating, you're getting closer to the heart of the statute. And one of the difficulties, I think, with the government's position is that I think it's harder to cabin that, to draw that bright line around it. It's harder than the government thinks it is. mean, to begin with, even the government seems to acknowledge, I think, that the exchanges are going to be relatively pale relatives of the exchanges as they're intended to be, where you're going to have standardized products. Everybody can come and make comparisons based on products that look more or less the same. But the other thing that's going to happen is with the subsidy program. The way that the subsidy program is set up, the subsidy is calculated according to essentially a benchmark plan. And this, if the court wants to look at the provisions, they begin at page 64A of the private plaintiff's brief, again in the appendix. The particular provision I'm talking about is at 68A. But there's a question. You're looking essentially to calculate the premium by looking at a standardized silver plan. First question, obviously, is there going to be any such plan if you don't have guaranteed issue and community rating, if the plans can basically be individualized? But the second problem is that in the provision on 68A, the provision that's used for calculating the subsidy, what is anticipated in the provision under the Act as it is now is that you have the floor of the income. You would take this benchmark plan, and the government would pay the difference. And as we talked about earlier, the benchmark plan can change for age, and the provision says it can be adjusted only for age. So if, in fact, you even have such a thing as a benchmark plan anymore, if the rates of people in poor health go up because of individual insurance underwriting, the government subsidy is not going to pay for that.
Mr. Farr, I understood that the answer that you gave to Justice Scalia was essentially that the minimum coverage provision was not the heart of the Act. Instead, the minimum coverage provision was a tool to make the non-discrimination provisions, community rating, guaranteed issue, work. So if you assume that all the minimum coverage is a tool to make those provisions work, then I guess I would refocus Justice Scalia's question and say, if we know that something is just a tool to make other provisions work, shouldn't that be the case in which those other provisions are severed along with the tool?
No, I don't think so, because there are many other tools to make the same things work. That's, I think, the point. And if the case that comes to mind is New York versus the United States, where the court struck down the take title provision, but left two other incentives essentially in place. Even without the minimum coverage provision, there will be a lot of other incentives still to bring younger people into the market and to keep them in the market. And if my reading of the finding is correct, and that's all that Congress is saying, that this would be useful, it doesn't mean that it's impossible to have.
I'd just like to hear before you leave your argument, if you want to, against what Justice Scalia just said. Now, let's assume, contrary to what you want, that the government's position is accepted by the majority of this Court. And so we now are rid, quote, of the two heart of the bill. Now, still, there are a lot of other provisions here, like the Indian Act, the black lung disease, the wellness program, the restaurants have to have a calorie count of major menus, etc. Now, some of them cost money, and some of them don't. And there are loads of them. Now, what is your argument that just because the heart of the bill is gone, that has nothing to do with the validity of these other provisions, both those that cost money or at least those that cost no money? You want to make an argument in that respect, that destroying the heart of the bill does not blow up the entire bill. It blows up the heart of the bill. And I'd just like to hear what you have to say about that.
Well, Justice Breyer, I think what I would say is if one goes back to what I think is the proper severability standard and say, would Congress rather have no bill as opposed to the bill with whatever is severed from it? It seems to me when you're talking about provisions that don't have anything to do with the minimum coverage provision, there's no reason to answer that question as any other way than yes, Congress would want these provisions.
The real Congress or a hypothetical Congress?
An objective Congress.
Right. Have you come across
not specific, not with a vote counting.
Why put Congress to that false choice?
Because,
you only have two choices, Congress. You have the whole bill, or you can have, you can have parts of the bill or no bill at all. Why that false choice?
I think the reason is because severability is by necessity a blunt tool. The Court doesn't have, even if it had the inclination, doesn't essentially have the authority to retool the statute.
Yeah. Well, and also, I would say stay out of politics. That's for Congress, not us. But right. the question here is, you've read all these cases, or dozens. Have you ever found a severability case where the Court ever said, well, the heart of the thing is gone, and therefore we strike down these other provisions that have nothing to do with it, which could stand on their feet independently and can be funded separately or don't require money at all?
I think the accurate answer would be I'm not aware of a modern case that says that. I think there probably are cases in the 20s and 30s that would be more like that. If I could just take 1 second to address the economist brief, because Justice Alito raised it earlier. I just want to make one simple point. Leaving aside the whole balancing thing, if one looks at the economist brief, I think it's very important to note that when they're talking about one side of the balance, may I finish?
Certainly.
When they're talking about the balance, they're not just talking about the minimum coverage provision. They very carefully worded to say the minimum coverage provision and the subsidy programs. And then, so when you're doing the mathematical balancing, the subsidy programs are extremely large. In year 2020, they're expected to be over $100 billion in that 1 year alone. So if you're looking at the numbers, please consider that. Thank you.
Thank you, Mr. Farr. Mr. Clement, you have 4 minutes remaining.
Amicai's point. He says that Congress didn't go into this act to impose minimum coverage. They went into the act to have a different purpose, i.e., to get people coverage when they needed it, to increase coverage for people, that this is only a tool. But other states, going back to my original point, that there are other tools besides minimum coverage that Congress can achieve the same goals. So if we strike just a tool, why should we strike the whole act when Congress has other tools available?
Okay. Mr. Chief Justice, I'll make 4 points in rebuttal, but I'll start with Justice Sotomayor's question, which is to simply say this isn't just a tool. It's the principal tool. Congress identified it as an essential tool. It's not just a tool to make it work. It's a tool to pay for it, to make it affordable. And again, that's not my characterization. That's Congress's characterization in finding I on page 43A of the government's brief. Now, that brings me to my first point in rebuttal, which is Mr. Kneedler says quite correctly, tells this Court, don't look at the budgetary implications. Well, the problem with that, though, is once it's common ground that the individual mandate is in the statute, at least in part, to make community rating and guaranteed issue affordable, that really is all you have to identify. That establishes the essential link, that it's there to pay for it. You don't have to figure out exactly how much that is and which boxes. I mean, it clearly is a substantial part of it, because what they were trying to do is take healthy individuals and put them into the risk pool. And this is quoting their finding, which is in order they put people into the market which will lower premiums. So that's what their intent was. So you don't have to get to the final number. You know that's what was going on here, and that's reason alone to sever it. Now, the government, Mr. Kneedler, also says there's an easy dividing line between what they want to keep and what they want to dish out. The problem with that is that, you read their brief and you might think, oh, there's a guaranteed issue and a community rating provision subtitle in the bill. There's not. To figure out what they're talking about, you have to go to page 6 of their brief, of their opening severability brief, where they tell you what's in and what's out. And the easy dividing line they suggest is actually between 300G-A1 and 300G-A2. Because on community rating, they say that A1 goes, but then they say A2 has to stay, because that's a way that you'll have some sort of kind of Potemkin community rating for the exchanges. But if you actually look at those provisions, A2 makes all these references to A1. It just doesn't work. Now, in getting back to an inquiry that I think this Court actually can approach, is to look at what Congress was trying to do, you need look no further than the title of the statute, Patient Protection and Affordable Care. I agree with Mr. Farr that community rating and guaranteed issue were the crown jewels of this Act. They were what was trying to provide patient protection. And what made it affordable? The individual mandate. If you strike down guaranteed issue, community rating, and the individual mandate, there's nothing left to the heart of the Act. And that takes me to my last point, which is simply this Court in Buckley created a halfway house, and it took Congress 40 years to try to deal with a situation when, contrary to any time of their intent, they had to try to figure out what are we going to do when we're stuck with this ban on contributions, but we can't get at expenditures because the Court told us we couldn't. And for 40 years they worked in that halfway house. Why make them do that in health care? The choice is to give Congress the task of fixing the statute, the residuum of the statute, after some of it struck down, or giving them the task of simply fixing the problem on a clean slate. I don't think that's a close choice. If the individual mandate is unconstitutional, the rest of the Act should fall.
Thank you, Mr. Clement. Mr. Farr, you were invited by this Court to brief and argue in these cases in support of the decision below on severability. You have ably carried out that responsibility, for which we are grateful. Case number 11-393 is submitted. We will continue argument in case number 11-400 this afternoon.